Good afternoon, everyone, and welcome to the Clifford Law Office's program, Ethics Jeopardy, Answers and Questions. For this webinar, attendees will be in listen-only mode. If you need technical assistance, please submit your request under the Tech tab located in the window on your screen. Someone will help you as soon as possible with any technical issues you may have. If you wish to submit a question, though, during the presentation, please use the Q&A window on your screen. Presenters will do their best to answer your questions. However, due to the thousands on this program and due to time constraints, we will get to as many of them as we can. Throughout the program, there will be polling questions related to the hypotheticals that will appear on your screen. Please take a moment to answer the questions as they are announced as they appear. We'd like to hear from you throughout the program. We appreciate your participation in the short program evaluation at the end. The program evaluation can be found on your screen just below the handouts. Now, to qualify for continuing legal education credit in certain states, please click on the verification pop-ups that will appear on your screen randomly throughout the program. If your state does not require verification codes, such as Illinois, you are not required to click on these codes. Click to the CLE certification process will appear at the end of the program. Your attendance, however, is being tracked. This presentation is being recorded. A link to the recording will be sent out to all registrants in the post-event email and will be available on the Clifford Law website at cliffordlawcle.com, www.cliffordlawcle.com. The presentation will now be turned over to Robert A. Clifford, founder and senior partner of Clifford Law Offices. Bob?
Well, good afternoon and welcome, everyone. I'm Bob Clifford, senior partner and founder of Clifford Law. I'm so very proud to be presenting this program with you all today. This is our 18th year of presenting this CLE program. It's been something that we've offered as a way of presenting very high quality 2 hours worth of professional responsibility credit and ethics. And we have nearly 5,000 lawyers today who are participating in this program and listening in from around 5 states throughout our country. And it's believed to be one of the largest programs of its kind. I am and have been committed to raising the quality of the practice of law in my law firm and also in the state of Illinois. Particularly when I served as the ABA state delegate in my time as president of the Chicago Bar. It's important to me to do that, and it's important to me and my firm to promote civility and goodwill among lawyers, and I hope those goals are achieved today in what we're doing. I hope that this is a timely program for you all, that it has the goals that certainly I have aspired to when my partner Pam Menaker and I came up with the ideas for this program. And I'm excited about it because here today we're presenting Ethics Jeopardy, answers and questions that are really timely. You'll see in a moment with the hypotheticals. And we're joined today by 3 outstanding panelists in the practice of law. We have Leah Gutierrez, who's the Illinois Administrator for the Attorney Registration and Disciplinary Commission, the ARDC. Leah, thank you and welcome. You're so kind to be here today. And then we have Jamie Kleppetsch, who's from DePaul University College of Law, my alma mater. She serves as Director of Bar Passage and Professor of Legal Practice. And then we have Judge Ray McKoski, now retired from the bench, but who also serves now as an adjunct professor at the UIC Chicago School of Law, and is also an author of a book, Judges in Street Clothes, Acting Ethically Off of the Bench. You can find out more about their particular expertise in their bios that are included in the materials that we have distributed to you all and are on my firm's website, once again, cliffordlaw.com. We encourage the thousands of you who are joining us today to ask questions. Everyone watching is muted, as Pam said, so please send your questions in writing as you are instructed to do in the materials, and we will try to get to as many of them as we can. And also, to increase interactivity, we will be asking a series of polling questions along the way that will appear on your screen. Please try to participate in those. They're very helpful. We'd like to hear from you. I do, but by the way, personal note of privilege, I do miss the in-person crowd that we used to have, because I always had the privilege of doing a shout out to Miles Bierman, the greatest family law lawyer in America. And hi, Miles, I know you're here. So without further ado, I'd like to turn this to our first hypothetical. So thank you very much. Let's go to those. So hypothetical number one: a lawyer employs a non-lawyer legal assistant, like so many of you. That assistant, Pat, provides secretarial services, performs basic legal research, and prepares details of wills and divorce pleadings. The lawyer plans to expand Pat's duties to include intake interviews with prospective clients. During the intake interview, Pat will she'll perform a conflict check. Then she'll obtain basic client information. She'll determine if the matter falls within the lawyer's areas of practice. She'll determine and answer general questions about fees and the representation. And then finally, if appropriate, she'll have the prospective client sign a fee agreement using probably DocuSign. That's our hypothetical. Our questions: do the rules of professional responsibility prohibit the lawyer from assigning Pat these intake questions? So you have four options: yes, no, Pat may assist in the intake function, or let me reread the ABA ethics formal opinion and find out if she can do these things. How about we turn to Judge Ray and maybe Leah? What do you both think?
Well, I'm going to make a correction first. It should be the rules of professional conduct, not responsibility there. That was my fault. But I want to welcome everybody also, Bob. We've got a wealth of knowledge out there with all these attendees, and I hope you share some of that knowledge in the chat or the question area. This scenario was meant to highlight a couple points. One, obviously, the duties and responsibilities of managing lawyers and partners and lawyers further down the chain that do actual supervision of non-lawyer assistants. And the rules require some supervision and training for a number of reasons, but one is to avoid the unlawful practice of law, which lawyers cannot assist in, according to Rule 5.5 of the model rules. The other point here is that we're going to examine ABA Opinion 506 that wants to focus in on non-lawyers' intake responsibilities or assignments and try to define which intake responsibilities might cross over into the unlawful practice of law and which intake responsibilities are fine and can be performed by a non-lawyer. And as this slide shows, the ABA opinion, which is pretty detailed on this, says assuming that the non-lawyer assistant is trained and supervised, and those are two different things, that the non-lawyer assistant has permissible activities, can obtain information about the matter. You can fill out a form and do that. Perform a conflicts check. A lot of times that's just pushing a button on software. Let's see, assist in intake, but not discuss. Oh, I lost it here. Sorry. Got it right here. Now I've got it. Perform initial conflicts check. Determine if the matter falls within the lawyers of expertise. An assistant answering certain fee questions, general questions, probably like, can I make my payments monthly or something like that. These are permissible. The ABA opinion says these wouldn't be the practice of law. The next slide shows some impermissible.
Before you go there, Judge, what do you do when that client says to Pat, hey, Pat, I really don't like your hourly rate. It's not competitive. You just quoted me $300 an hour. I mean, I'd be willing to pay $250. Can you do that?
Yeah.
Leah, what do you think about that? Or Judge, what do you think about that?
The client can do that and ask the questions. According to the ABA opinion, when there's a discussion about fees, and a changing of fees, the lawyer has to make that decision. So the lawyer would have to intervene and say, yes, we'll reduce our rate, or no, we won't. That would be the practice of law negotiating a fee.
So as part of the training, we would then, so if you're going to have Pat doing this work for you, Pat needs to be trained to say, well, thank you, I will take that question to my senior partner, and he will respond. That's the proper training?
That's exactly right. The opinion says the lawyer does not have to respond face to face with the client. So Pat could text or call the lawyer and say, are you willing to reduce the fee? The lawyer could say no, and Pat could convey that to the client. But that would be the practice of law negotiating a fee.
Okay, very good. Leah, what do you think about that?
No, I agree with everything that's been said so far. One thing that I want to point out is, while the non-lawyer assistant can help with these basic tasks, one of which includes communicating the fee and getting the client to sign the fee agreement, if there's more than basic things in that fee agreement, things like arbitration agreements for fee disputes or for malpractice claims, those things really need to be explained by the lawyer. That's more complex than a non-lawyer assistant should be explaining. So it really is the non-lawyer helping with more basic routine things, not things that constitute the practice of law. And I think that kind of begs the question about what constitutes the practice of law.
We have a question here because we're already getting in several. And Elizabeth is asking, what is the public policy behind this rule? Because it doesn't seem like the practice of law.
Well, but part of the public policy is confidentiality. The non-lawyer assistants might not be as familiar with confidentiality requirements, and so the supervisory responsibility of the lawyers is supposed to concentrate on that. But a part of it is unlawful practice of law. The ABA opinion says that, and that's why the lawyer has to respond to fee issues or issues about what kind of services the client should get. And ultimately, the goal is to protect public confidence in the legal system.
And Judge, go ahead, Pam. I'm sorry.
James is asking, what if the lawyer gives the assistant a range of fees that are acceptable? Is that allowed by the lawyer?
I have an opinion, but Leah or Jamie, go ahead.
I think that once the client starts to negotiate, I really think that the lawyer needs to come in at that point. It goes beyond, again, just the basic intake and, a basic fee agreement, but now getting the client to, agree to what the terms of the representation are going to be with the lawyer. That really needs to have the lawyer's involvement. Judge, what are your thoughts?
Yeah, I agree with that. The non-lawyer should not be setting the fee, even within a range, in my opinion. When there's discussion about the fee, changing the fee, the lawyer needs to make the decision.
Right, and that's certainly what happens in practice when, especially in the injury tort law area all the time, when you're going to get a client who's going to want to negotiate, and you have to have the lawyers, because it's a judgment of the person on the lawyer side who's extending the reduction in fee hypothetically, and that's a judgment, right? And I think that has to be turned over to the lawyer. Pam, go ahead.
Another question, George Bellis is asking, can this be assigned to an AI chatbot? And before we move on to the next hypothetical.
That's great. And Pat in this hypothetical is a human. The rules governing non-lawyer assistants in the ABA Model Code say this is a real person. There is a lot of intake being done with chatbots, in lemon law cases especially. Some of the ethics opinions have made note of this. And this is an area, because I'm old, just seems strange to me. You're going to sign an agreement with a chatbot?
Well, it's happening, Judge, maybe. We'll see.
Right.
That might be next year's program.
I think it is.
But Bob, I wanted to go back to the question somebody asked about the policy behind, I guess, the limitations on what the non-lawyer can do. And I think it's important to talk about how our court has defined the practice of law, at least in Illinois. And basically, it's the giving of advice or the rendition of any sort of service when that advice or rendition of service requires the use of any degree of legal knowledge and skill. Now, it's not a really clear definition, but essentially, anytime we're stepping into the realm of requiring a degree of legal knowledge or skill, we want to make sure that clients have the benefit of somebody who is licensed to do that, as opposed to a non-lawyer assistant.
There you go. Hey, by the way, I had asked us the issue before we began the program. I was asked a question earlier today when someone said to me, they said, you got these rules of professional conduct, and then you got these ABA formal opinions, rules, opinions. Come on, what is that? Are these binding on us? Are these aspirational? What are they? Leah?
Yeah, I would say that the opinions, the Bar Association opinions, whereas ISBA, ABA, those are advisory in nature. They provide guidance and interpretation of rules, but the rules of professional conduct are, the standards to which the court is holding us all as lawyers. Those are the expectations that we're going to abide by those rules of professional conduct.
Yeah. So they're not just guidelines, everyone. So there you go. Okay, Pam, let's go.
We have a chance for one more quick one. Josh was asking, in a multi-lawyer firm, who is responsible if the non-lawyer assistant exceeds their authority?
The guy whose name is on the door.
I knew you were going to say that. Okay.
It depends. The most logical person is the one who's supposed to be supervising. The lawyer is supposed to be supervising. But if the partners don't enact policies and take reasonable measures to make sure there aren't violations, they can be responsible too. But the first look is at the person, the lawyer who's supposed to be supervising the non-lawyer's conduct.
There you go. Okay, Pam, let's move along. Okay, hypothetical number 2, everyone. An attorney received a phone call from a father asking the attorney to represent the father's son, a 21-year-old college student involved in a DUI charge. The father told the attorney that he would pay the attorney's standard hourly rate for the compensation as well as any expenses. The following day, the attorney met with his son and discussed the matter. And when the son told the attorney that he didn't have much money and asked how much money would charge for the representation, the attorney responded that the son's father had agreed to pay already, so don't worry about it. As the trial date approached, the prosecution offered a plea deal, and the attorney brought the deal to the son, not the father, who accepted it. When the father later learned of this, he was furious with the attorney for failing to include him in the discussion regarding the plea deal. I think we could see something like that happen. Were the attorney's actions in representing the son proper? Yes or no? Leah?
Actually, I think that number 2 is
Jamie?
Oh, Jamie, I'm sorry. You're right.
That's okay. That's all
Bad
right.
Bob. Bad Bob.
Well, when we're looking at 1.2, 1.4, we're looking at who is your client and who makes the decision. So if somebody else is paying for the representation, they are not the decision maker. It's the client who's the decision maker, and you have to follow the client's instructions for that. When you're communicating, I think one of the problems in this fact pattern is that when the attorney is communicating with the son, yes, he does tell him that father's paying, but the rules require that you get informed consent for somebody else to pay the bill. So just saying, don't worry about it, dad's taking care of it, is not really complying with informed consent, because you have to give them all of the information, the positives, negatives, and so that they can make that decision. So there's kind of an issue there with the way that they've communicated with the client on that. So they do need to give them the opportunity to say whether they even want that person to pay or not, and what does that mean? What do they have access to? What can they learn? Which is pretty much nothing. They can pay the bill, and that's about it.
What if the son, though, was under a mental disability or a minor? Okay.
So 1.14 is going to handle a client with diminished capacity, and that covers clients with mental disabilities and being underaged. And what the attorneys should be doing is they should try to maintain as normal an attorney-client relationship as humanly possible and not involve others unless there is substantial risk of financial or personal harm that could come to the client. The fact pattern that we don't have enough information in that to tell us if there's going to be that substantial risk in there. If there was, then they would look to who do they need to talk to? Would a family member be an appropriate person? Do they need to seek an appointment of a guardian in that case? And then they can only communicate as much as reasonably necessary. It's still not an open book to that additional person.
Right. And by the way, audience, all of these slides and this full citation to the rules and every site we're talking about is included in your program materials. Well, I think that's about all we can accomplish on that one. Pretty
Well,
straightforward.
we do have Eric asking, Bob, just
You
what
got
if
some
the father,
questions? Yeah.
what if the
Go ahead.
father has a durable power of attorney? Does that make a difference, Eric is asking?
Again, when you're looking at, you're still trying as the attorney to have that normal attorney-client relationship. So the rules don't, regardless of whether there's a power of attorney or not, the rules don't allow the attorney to communicate with somebody else unless we have those substantial risks. If the client can understand the nature of their claim and what's going on and can make reasonable decisions, then we wouldn't involve somebody else. So if in the instance where we're at a point where the client doesn't understand what's going on, they may need help with that, then we can involve somebody else, but only to the extent necessary.
Is there ever
Mike
a
is-
time, but before you get to that, Pam, is there ever a time, because we've had this issue come up in cases where there's such a conflict between what the now adult child wants and what the father is kind of badgering about, where the lawyer has a duty to bring this to the court and ask for the appointment of a guardian of some kind?
It could get to that because you've got because again, in this situation, the adult child is the client and your responsibility is to your client, not to the person who's paying the bill, and trying to protect your client's interests to the best extent that you possibly can. And so if you've got those two butting heads, then it's probably your next step is probably going into the court and having a guardian appointed because you're not going to get very far or be able to help the client if the parent is giving wishes contrary to the client.
Right. Pam?
Yeah, Mike is asking, does the analysis change in the insurance defense situation where the insurer does control the defense and pays the attorney? How does that change this?
So the client is still the client. So even though the insurance company is paying the bill, the son is still the client. So you don't have necessarily, it all goes back to confidentiality. You have to look and see what can you share. The client could approve. You can ask the client if they would approve sharing information with them. But if they're protecting the client's interest, the insurance company is just paying the bill. They're covering that. But the son is still the client in that scenario.
Okay, and then Joseph is following up with when the son did not object to the father paying, wasn't that indicative of informed consent?
No, because the attorney didn't provide the information so that the son could make an informed consent. So it's all about what is the information that the attorney is providing to the son to be able to give informed consent.
Right, so then
And
Bradley is saying, to what extent then should these kinds of details be covered in a written engagement letter?
the written engagement letter the rule doesn't require it to be in writing, but you protect yourself as much as you're protecting the client if you put it in writing. So, you could put that into the engagement letter, but it's not necessarily going to be required to do so just because this particular rule doesn't require that be in writing.
Okay, thank you, Paul. Pam, any more questions? No. All
I
right,
could
moving on
answer
to
one more if you want. There's a lot, but we'll go with maybe one more. Can the son authorize the lawyer to provide confidential information about the case and provide confidential information to the parent that is paying?
Yes, the son can. So the client can give consent to whomever they want to have the information. The lawyer can't make that decision on their own. The client has to give that approval. So if the son says, yes, you can share everything with dad, then the lawyer's okay to share everything with dad.
Okay, well, fair enough. Thank you for those. Moving on to hypothetical number 3. Carrie Careless is defending Bleach in litigation. You know, every time she does this to me all the time, she comes up with these names, and every year I want to change them, and I never do. All right, so Carrie Careless is defending Bleach in litigation regarding violations of environmental statutes. A main issue in the case involves Bleachy's disposal processes and notice of harm to the local residents. The case has been pending for years. Casey is walking over to court for the final pretrial. Carrie gets an email from Bleach's CEO, Pat Prickley. You must stay up at night thinking of these things. Forwarding a 2010 email from a local doctor, Dr. Doolittle, indicating the doctor has seen a rise in cancer cases among the town's residents. In the email, Dr. Doolittle kindly inquires whether Bleachy's waste disposal processes meet the requirements of pertinent environmental waste statutes. You've never seen this email from Doolittle before, but the pretrial is in 5 minutes. You believe this email and information could negatively affect the case, but you would like to look into it a bit further to see what it is really all about. Well, that's a good one. So here we go. What do you do when you get this email? Nothing. Ask the court for an extension. Pull aside the opposing counsel. Tell the court about the email and ask the court for permission to take Doolittle's step. Leah, what do you think?
Well, so as attorneys, we've all faced those moments when new information lands in our lap at the worst possible time, sometimes right before a critical court appearance. So I think this scenario presents an ethical dilemma involving the attorney's duties to the court, to opposing counsel, and to the overall fairness of the proceedings. So upon receiving previously undisclosed email from the client's CEO moments before the pretrial conference, the lawyer has to decide how to proceed. And at this point, the lawyer really doesn't have a lot of information. He doesn't know whether his clients received it, doesn't know whether the client responded to it. If he did receive it, it's not clear how it may contradict previous statements made by the client. But now that he has it, what's his obligation? So looking at the responses coming in, and it looks like most of us, about 68% are saying ask the court for an extension, with some saying some other things. So some of the rules that are implicated here, we know we have duties under Rule 3.3, which is our candor to the tribunal not to mislead the court. Under 3.4, fairness to opposing counsel to ensure that discovery obligations are met. And under 4.1, which is truthfulness in statements to others, not to make false statements or even incomplete statements that could be misleading. So I would say the best course of action here is to request a continuance to allow time to investigate. At this point, we simply just don't have enough information to determine really, whether this is material, how it affects any prior statements the client has made, or so on and so forth. So asking for time to investigate allows us to ensure that we're complying with our ethical obligations without prematurely disclosing something that may or may not be relevant. I do want to acknowledge that, I'm sorry?
No, go ahead, please.
Okay. That asking for a continuance isn't a guarantee, right? The judge might deny it or might demand more information on the spot. Opposing counsel might object to a continuance. And if that happens, we got to be prepared to explain that the email was just received or the information was just received, that it hasn't been reviewed, and that it may be significant. I think the key here is to be transparent about the situation without making definite representations until we have the full picture.
Jamie?
I agree. I read this fact pattern, and you have that knot in your gut where you're like, oh, I don't know if this is going to be bad. It doesn't feel good, but I don't know if it's going to be bad or not. So yeah, absolutely agree. Try to take that continuance if you possibly can, if the court will grant it, so that you can get some more information and see what you need to do with the information before you unnecessarily maybe alert to something that isn't going to turn out to be anything.
Yeah, I think this fact pattern the answers could vary depending upon the nuances of the fact pattern, right? I mean, here, Doolittle is not anyone's client. He's an outside third party. So there, because what jumped in my mind as I first read this, I was thinking, okay, is this a privileged document? It didn't seem to be, and doesn't seem to be. Although query as to if it's something that's a document that pertains to the care and treatment of a patient, then you might have an HIPAA issue. There are a lot of twists that you could make that would make it a real problem for the lawyer. I mean, under this fact pattern, he probably has to disclose the email and give the court a basis, because the court, otherwise he's going to ask the court, for a blind continuance. And to, Leah's point, there's no chance, there's no guarantee that you're going to get that continuance. So, Pam, what kind of questions are you getting?
Well, some people are asking, in other words, I know somebody's talking. If a continuance is denied, must this be disclosed?
I think at that point,
Yeah, how could you get the continuance without it being disclosed? That's what we were just talking about.
yeah, I think you have to disclose some degree. If the continuance is denied, or if the judge is asking for more information, you're going to have to disclose some information about what was just received and say that you need the opportunity to look into it further. I mean, at this point, you haven't really had the opportunity to do anything. You received it as you were walking over for the pretrial conference. So yeah, I think that if you need to, you're going to have to disclose what you've received.
There you go.
And then Jeannie's, okay, to clarify that, thank you. And what if the client and the court threatens and imposes a default judgment for failing to cooperate? Can or must the attorney report this to the insurer prior to the imposition of sanctions?
Judge, you want to take a shot at that?
As far as reporting it to the insurer, I don't know that. I can say that it's going to be a very rare instance where a judge is going to enter a default that day. The judge is most likely to say, okay, I don't like it, but you have a short time, you got 3 days, you got a week, you got to be back here and tell us what you're going to do with this email. A default at that point is pretty unlikely.
And Stephen is asking, would it make a difference if this was somebody going to answer something else or add? Would it make a difference if this was a criminal case and the email was received from the police investigator telling the prosecutor they had a prior false confession from a person, not the defendant? I don't know if we're getting specific here, but I guess if you want to address it as a criminal case.
Anything that could be favorable to the defendant needs to be turned over. Things like this happen sometimes where the prosecutor gets an email 2 years after the arrest or whatever because the police just found it. But if, this is a little different because the false confession was in an unrelated case. But if it had any arguable effect as mitigating guilt or sentence, the prosecution has to turn it over immediately.
And then Edwards is asking, can the lawyer proceed with the pretrial without disclosing the email so long as there's no violation of the duty of candor?
I can give you... No, go ahead, Leah.
No, go ahead. I'd love to hear your thoughts. I was just going to say, this fact pattern, there's not a lot of detail in it, so I don't really know where we are in the case. And I think that is a fact that I would want to know before really answering that question. I think depending on where we are in the progression of the case, it is possible for it to be perfectly within the rules not to say anything at that moment, as long as you investigate and do so in a timely fashion, depending on what you discover. But I'd love to hear from you, Judge.
I don't disagree with that at all. It does depend on the facts a little bit. But I can say this with a pretty high degree of certainty. Judges, as a general rule, do not like a lack of candor. They don't like deceit, express or implied. Judges don't even like mild surprises, you know. So I think in this situation, especially since the case has been pending for a while, the lawyer needs to say something to protect themselves. Um, I got the email, I need a couple days, I don't know what it means, rather than doing nothing to avoid the possibility that he has to disclose the email and the judge asks him why he didn't mention this before. I think the best practice is for the lawyer to mention something about the email, that he got it, he needs to look into it before a pretrial is going to be effective.
I agree with that.
Okay, time to move on. Okay.
Okay, Pam, let's move on here.
Mhm.
Okay, hypothetical number 4. The client retained attorney to pursue his personal injury claim based on an automobile accident in which he suffered a serious brain injury. The attorney met with the client to discuss his claim and then contacted the liability insurer for the defendants. There was some further contact between attorney and client regarding the aggravation of the client's injuries. As time went on, client made multiple attempts to contact attorney through emails, phone calls, and text, but the attorney did not respond to the client, cut off communication with the insurer, and failed to file suit by the statute of limitations deadline. Eventually, the client notified the attorney by email and U.S. mail that he was terminating her representation and requested that she provide him with his file. Less than 5 minutes after receiving the client's email, attorney texted the client asking, "Are you firing me? Why?" The attorney and client had no further contact, and the attorney failed to provide the client with the requested files. No written contingency fee agreement exists. Now, before you all say that can't happen, this is from an actual case. And when I first became aware of it, I'm thinking, I don't understand that stuff. So anyway, was the attorney's conduct proper? I suppose I answered the question already. This is a polling question. The answer being no. But maybe Leah or Jamie first, you have a different opinion.
No, I agree. Their conduct's not proper. After I found this case, this summer I had a family member who went through a very similar situation where they had hired someone, had reached out to the attorney repeatedly, never received any communication back, had to show up at their office just to get any sort of communication with them. So unfortunately, I'm finding it happening more often than I thought that it would. This is, implicating your rules on communication. You have to communicate regularly with clients. You have to return their contacts. It's reasonable communication, right? If your client's calling every 5 minutes and you're responding to them, okay, you've got it. You've taken care of it. They don't need that much, but they need more than nothing, right? So here, this was a very long period of time that this client was trying to contact the attorney and was getting no response back from any of their messages. Also, if the attorney has to make sure that they are working up the client's case diligently. So they have to be working in the best interest of the client, clearly blowing that statute of limitations, not going to be in the client's best interests. If they are too overwhelmed by either their caseload or maybe personal circumstances and something like that, they need to communicate that with the client and discuss whether or not they can continue handling the case and what those parameters might be. So all of those things are implicated there. There's more problem with, at the end of this fact pattern, we have I think this is the one where the attorney doesn't give back the client files, and you have to. There may be a limited situation where you might be able to hang on to them if they haven't paid for fees that you have earned up until that point. But there's nothing really that this attorney has done for the client. There's no reason to hang on to their files. You need to turn them over at the termination of the representation. And a client can terminate you for any reason, good, bad, or ugly, at any time. So we have to have more reasons to terminate that representation and get more permissions and stuff like that. But the client can come in and say no, but this obviously is a reasonable termination by the client after all this lack of communication.
Leah, would any of that change if the client had fired the attorney before the statute of limitations ran? And would the attorney still be subject to discipline?
Sure. So let me start by just piggybacking on something that Jamie said about, much to her chagrin, she's learning that this happens more frequently. I just want to say that this is a significant portion of the grievances to the ARDC against attorneys, neglect and failure to communicate. If you look at our annual report from 2023, which is our most recent annual report, 26% of all grievances involve allegations of neglect, 17% pertain to failure to communicate. And those issues are among the top 5 allegations reported to the ARDC every year without fail. And so this is a really significant issue for lawyers. Your question, Bob, about, if the attorney had fired the client or terminated the representation before the statute of limitations had run, the lawyer still neglected the case. The lawyer still failed to communicate with the client. And so there's still a rule violation here. I think that your question is, would the ARDC maybe have taken the case? Would this lead to a formal prosecution? And the answer is it depends. Obviously, one of the factors we consider in determining whether or not to file a formal charge, which even when there's a demonstrated violation of the rules, we don't always do. One of the factors is, was there actual harm? Or what is there the potential of harm to future clients or future individuals? If this is an isolated instance and there wasn't harm to the client, we see that the attorney has put some parameters in place, or we're able to divert them to a program that helps them with law practice management, for instance, then maybe something like that would not lead to formal discipline. If, however, we're receiving allegations from multiple clients that the attorney is neglecting cases, even if there is not an actual harm to one of those clients, it may be an indicator of a bigger problem that would probably lead to formal discipline.
Bob, can I make this unanimous? When I first started teaching professional responsibility as an adjunct, I was amazed at the number of situations like this, where the lawyer did nothing, and in many of them, the lawyer would tell the client, yes, I filed a complaint, yes, we're in negotiations to settle it. Sometimes the lawyer would say, we settled it, and then try to pay the client out of their own money because they neglected the thing. The number of these cases is pretty amazing.
Well, I think, speaking as someone who runs a firm, I think one of the disciplines that you really have to develop, and either for yourself and or teach it to lawyers in your office, is that, once they are engaged, once I agree, the lawyer agrees to represent the client, it behooves you to formalize the relationship, get it in writing, and develop some procedures to make sure you are communicating. I was shocked by, reading this, and yet I think, anecdotally, I read the report that the ARDC puts out, as Leah is describing, and lawyers are the ones that they're their own worst enemies, and it's something they don't necessarily always have good business practices, and there are law management programs available, and best practices that we can all study as part of the CLE programming. I know that the ISBA presents, ABA does it as well, also. So, Pam, I think there's another polling question.
Bob, I think we have another question before I get to these questions.
Yeah.
Okay.
So what if the attorney was sending email communications to the client throughout the representation, but the attorney misspelled the email address for those communications? They never reached the client. Would the attorney still be subject to discipline? Leah, if you're able to speak to that.
Yeah, it's still on the client, on the attorney, excuse me, not the client. It's still on the attorney to ensure that they have the proper, means of communication with their client, and that those communications are being received. If the attorney is communicating with the client and they're not receiving any responses, and they didn't do anything to try to reach out to them by other means, the client is still not getting the information that they need to get to. So the onus is still on the attorney under 1.4 of the rules of professional conduct. So the answer is yes.
Okay.
And Joseph is asking an interesting question. Can the lawyer arguably withhold the client file on the basis that he will most likely be defending a malpractice claim?
I'm glad that question was asked, because I wanted to go back to this notion of a retaining lien. I know Jamie had touched on it, and while there is this kind of common law, thought that you can hold on to your client's file, it's probably not a good idea to do so. It can hinder the client's ability, for instance, to seek new representation. It can result in further harm to the client. And if it does, then that's actually going to cause a problem for the attorney under Rule 1.16. And so I think that there's other means of recouping your fee that lawyers can avail themselves of, as opposed to holding on to the client's file. I just don't think that that's the best way of accomplishing that. Is risky for the attorney.
And that's right.
Also, having presided over some litigation of retaining liens, it's generally a losing proposition. It's not a good idea.
Well, but to Leah's point, the first thing that comes to mind is the hindering of the client's ability to further prosecute the case. And that's a major mistake. That's only going to lead to either more aggravation of the potential malpractice claim against the lawyer. I mean, I think it would be prudent for the lawyer to make a copy of the file for his or her file down the line to that, defense of the malpractice case. You don't want the client hypothetically or someone hypothetically saying, well, you never gave me this information that would have helped me prosecute my case. And then, in fact, you have the copy of what you gave and tendered over to the new lawyer or to the client. I think that would be prudent. So, okay.
One other quick question, I think Leah touched on it earlier, that Mary is asking is, attorneys are supposed to respond in a reasonable time. And do the Illinois rules give guidance on this? Is 24 to 48 hours reasonable?
I think it's going to depend on the circumstances. And again, Jamie talked about clients sometimes not having reasonable expectations. Some of this is about the expectations that you set with your clients at the outset, making them understand, you're going to try to respond within a certain time frame. You can be with another client, you can be in court, and you want to give those clients your undivided attention, just like you want to they want your undivided attention when it's their turn to be in court. So I think it's managing those expectations, even if you're not able to get to the substance of what they're asking, maybe even just touching base with them to say, hey, I received this. I'm in court right now. I'm in trial right now. I'm doing something right now. You can expect to hear from me by X date. That's managing, the communication with the client. But you're right. The rules are silent on a specific time frame. It's really what's reasonable under the circumstances. And the ARDC prosecute, fringe cases. If somebody's not, responding in a couple of days, that's not something that the ARDC is going to be concerned about. It's those cases where the client is not getting any information about their case, or the attorney is not responding to the client's request for information about the case.
At all, you mean? Okay.
All right, Pam, let's move on. Well,
Okay.
you got one more. We have time for one more question if that's what you had, though. Go ahead.
I do, but I think we have to move on. But we have Karen asking, if you realize that you didn't comply with the rules of conduct, and I don't know if Leah touched on this earlier, really generally, what should an attorney do if there is no harm to the client or to the opposing party?
You mean like a self-reporting thing?
Right. There's no harm to anybody, but the attorney realizes, oh, I blew the rules.
Well, that's a good one, Judge. What do you think? Is this a no harm, no foul deal?
Yeah, my opinion, when I've answered questions like this for judges on whether they should report or self-report, my advice is, not very specific, but my advice is, before you self-report, go talk to a lawyer. Hire a lawyer, talk to a lawyer, get that lawyer's judgment on whether you need to self-report or not.
Hey, Jamie or Leah, do you want to add to that?
I like that.
I think that's good advice. But I think outside of a conviction of a crime, if we're talking about a situation like the hypothetical before us, where you've neglected a case, even where there is harm to the client, there's no duty to self-report that. But taking as much corrective action as possible to help prevent further harm to the client is really what you should be focused on at that point.
Right. Okay, moving on. Hypothetical number 5, slide 30 in our deck. A judge is Facebook friends with a criminal defense lawyer who regularly appears before the judge. The judge and lawyer have no other relationship outside of the courtroom. The lawyer appears in court representing 3 defendants set for arraignment. Polling question. Taking into consideration your state's code of judicial conduct, the judge should A, disqualify himself from the lawyer's cases, unfriend the lawyer and continue to hear lawyer's cases, disclose the Facebook relationship when the cases are called, or D, decline to disqualify or disclose and simply hear the lawyer's cases. Very interesting. Jamie, what do you think about that?
There's on
That's
social
interesting.
media,
Yeah.
we don't have, I know we want to say we have 5,000 friends, but we don't really. So it's one of those situations where if it's just a social media connection, you don't really need to disqualify yourself in that scenario. Was that, Judge, was this your question?
Yeah.
No. Yes. Well, yeah.
That's all right.
Both of you.
My personal opinion is I agree with Jamie, although the states differ on this. And the beginning of the question, your state's code of judicial conduct, is sort of a misnomer because every state's code of judicial conduct that I'm aware of has the same test for disqualification, judicial disqualification. If a judge's impartiality might reasonably be questioned, whatever that vague statement means, the judge needs to disqualify. Now, does a Facebook friendship by itself automatically require disqualification because it automatically puts the judge's impartiality in question in reasonable minds? Different states have come to different conclusions on this. So if you are viewing us from Massachusetts or Connecticut or Oklahoma, their ethics opinions have said from those states, automatic disqualification by the judge if the judge and lawyer are Facebook friends. Doesn't make any difference if you ever met the person or not, or even know them. If you're Facebook friends, you have to disqualify. California says a different answer. You can unfriend the lawyer and continue to hear the case. California also says you can disclose your friendship with the Facebook friendship with the lawyer and continue to hear the case. Some states have held differently, the last answer in the polling question, and that is, generally speaking, you can just continue to hear the case. Facebook friendships, like Florida Supreme Court say, are basically meaningless. If we see the slide before this, we have a slide with the Herson opinion.
Right.
Do we see that?
That's
And
out
if
of
not,
Florida. There you go.
This is Jamie's opinion and would be my opinion too. Friendships on a social networking site between a judge and a lawyer appearing before the judge standing alone does not reasonably convey an impression of an inherently close or intimate relationship that might warrant disqualification. Now, if you're Facebook friends and you take vacations together, you spend holidays together, you're each other's kids' godparents, maybe those things add up. But Facebook friendship is not an automatic disqualifying factor, according to this case, and I think that's the best view.
Very good.
Do
Well,
we have any questions coming in on this? And that is, not to date ourselves, but a few people such as Gary and Eric are asking, would it be different if it's LinkedIn instead of Facebook and the other social media platforms?
There are some ethics opinions on this that treat LinkedIn the same way. So the states that say Facebook friendships are automatically disqualifying also say LinkedIn connections, quote unquote, are disqualifying. The states that say Facebook friendships aren't automatically disqualifying say LinkedIn isn't automatically disqualifying. Although LinkedIn is more business relationship than personal friendship, but they follow. Facebook friends and LinkedIn connections follow.
And
probably
Allison
an
is asking,
ever-changing thing. Pam?
That's right.
Allison and others are asking, putting a spin on it, if the judge and lawyer were friends before the judge was put on the bench, and they have no other social contact outside of Facebook, does the relationship still need to be disclosed? Should they unfriend? Should the judge even be on social media to begin with?
Well, I certainly have opinions on most things. People are on social media. People like me at my age, and I don't want to shock anybody, but I'm old, I could get off of social media and not have one single problem. A judge who's 35 or 40 years old, who's been on social media their entire life, it is part of their life, don't think of getting off. And ethics opinions
What,
say
what,
judges
what
can
is
be
your
on
definition? What is your definition of old, by the way?
Oh,
Don't fall for it.
God.
Don't fall for
You
it.
and me
Speak
don't
for
fit
yourself.
in the
Speak for
category.
yourself. I think there are a lot of people on this program who want to say, speak for yourself, man.
That's right.
And the beginning part of the question, in some states like California, if the lawyer appears in front of you and you're Facebook friends and you unfriend, that's good enough. You can hear. But it depends on the state. My opinion, like I said, is like Jamie's, is you got to have more than a Facebook friendship to have a connection, to have a relationship so intimate to put in doubt the judge's impartiality. You need more. Vacation together, godparents for the kids, something.
All right,
And then
this
we
is
have
good.
here from Adam. From Adam, one last question, Bob, before we move on, hopefully quickly. Does the automatic disqualification rule result in gamesmanship and abuse, such as where a lawyer who doesn't like a judge can make a friend request and get the judge disqualified?
That is an argument that has been made, similar to the argument in states that elect judges with a cap or with a rule that if you contribute to a judge, like Utah, if you can contribute $50 to a judge, it's automatic disqualification. So some lawyers donate money to judges to trigger the automatic disqualification for campaign disclosure, campaign contribution. Same thing on this, the questioner's right, and that has been argued.
Okay,
Okay,
do you want to
Pamela.
move on?
Yes, please.
I have loads of other questions, but I think we have to move
Oh,
on.
give us pick the one that suits your fancy. Give us one more.
Pick one that suits my fancy. Okay, oh, somebody says here, Barry, you're only as old as you feel, but that's a comment. And here's about funny. I won't give his last name. And there was something about also if you're friends with the judge's wife, does that make a difference?
Could be different. It's at least once removed, but my opinion's the same. You're friends with the judge's wife on Facebook. That's even less important than being a direct friend of the judge. But it depends on the other parts of the relationship. And I might also add, lawyers need to be careful on friend requests because Jamie or Leah could correct me if I'm wrong, but Rule 8.4F, a lawyer shall not knowingly assist the judge in conduct that violates the Code of Judicial Conduct. So lawyers need to be careful if their state doesn't allow these connections, not to make the connections, or at least if they do, when they appear in front of the judge, to tell the judge, as you know, we're Facebook friends.
There we go. Okay, let's move on, Pam. To Hypo
Okay.
6. Hypothetical number 6. Larry Lawyer deposed a 20-year-old Tina Tech in connection with a personal injury case. Tina's testimony was that she had observed Larry's client, the defendant, driving through a red light just prior to the accident. During her deposition, Tina revealed that she had a Facebook account. Through some of the things that Tina said at her deposition, Larry believed that Tina's Facebook pages might obtain information that would help him impeach her testimony. Larry has several handsome young investigators on his staff who are savvy about the workings of Facebook. So Larry has one of his investigators friend Tina on Facebook, and from pictures posted on her account, discovers that she was at a raucous party just prior to the time she witnessed the accident. Hypo questions. Is there an ethics violation on that one? Leah, what do you think about that?
Yeah, so the lawyer has directed an investigator to friend, speaking of Facebook, somebody on Facebook under false pretenses to gather potentially impeaching information. So this scenario raises, I think, significant ethical concerns under rules 4.1, 8.4, and 5.3. So Rule 4.1 is truthfulness in statements to others, and it mandates that lawyers not make false statements of material fact or law to third persons. And I think in this scenario, instructing an investigator, I shouldn't say I think, I mean, the case law is really clear, instructing an investigator to misrepresent their identity to gain access to a witness's private social media information constitutes a false statement in violation of Rule 4.1. Rule 8.4 C specifically states that it's professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. So again, the act of pretexting or using deceit to obtain information falls squarely within the behaviors prohibited by this rule. And then finally, Rule 5.3 is about supervising non-lawyer assistants. I think we talked about this rule earlier, but lawyers have to ensure that their non-lawyer assistants' conduct is compatible with the professional obligations of the lawyer. And so in this case, by directing or allowing the investigator to engage in deceptive practices, the lawyer is failing to uphold their supervisory duty. So there's been a lot of cases relating to this across the country, actually. One that comes to mind in 2020, there was a New Jersey lawyer who represented a police officer and a police department in a personal injury action that was brought by a man who was hit by a police car while he was doing push-ups in a parking lot for some reason. But the lawyer instructed his paralegal to research the man online. Initially, the man's Facebook profile was public. The paralegal monitored it, but then the profile was changed to private, and the attorney instructed his paralegal to friend the man on Facebook and continue to gain information. And she did. She did it using her true identity, but not disclosing that she worked for the attorney. And then when she did that, she found some private information that actually tended to impeach the man's injury claims. There was a video of him wrestling with his brother. So the attorney was brought up on disciplinary charges for having the paralegal contact a represented party and engaging in deception.
There you go. I think that one seems pretty obvious.
Hopefully.
What if the information was obtained by a private investigator using the same technique?
Again, if the lawyer is directing it or is aware that the private investigator is engaging in that conduct, the lawyer is going to be responsible for that. The lawyer has the responsibility to supervise, whether it's an employee or any parties that the lawyer is contracting with to investigate the matter.
What if the lawyer, no, wait a minute, but what if the lawyer says, okay, listen, I got this case, go do what you do. You're the investigator, you got a license, you've been trained, go do your thing and get back to me. And then this happens to come back. What do you think about that?
The best thing for the lawyer to do in this situation, if you're hiring a private investigator, is to set some parameters at the outset around what the investigator can and cannot do. So certainly you can look at social media as long as it's public. Do not, friend anybody, pretend that you're someone else or not involved in the case. The lawyer really needs to be that specific.
Good. Very good. Well, thank you. Pam, unless you got some questions or no?
Well, I'm trying to sift through here. What if the paralegal had her employment listed on her Facebook profile, so therefore there's transparency? Asking here.
Yeah, I still think friending someone and not out and out stating to the person that who you are and what your interest is and what your interests are in looking at their Facebook profile. A lot of people are, just quickly to the point that Jamie and was making earlier, that those friendships are really superficial. People don't necessarily look at who they're accepting a friend request from oftentimes, and so simply having that listed, I don't know, gives the person enough notice that they're friending someone who is looking into the case. Yeah.
People,
I agree with that. Even if you use your right name and your right job, you're saying, in effect, I want to be friends with you on Facebook. What you really need to say, to not be deceitful, is I want to be friends with you on Facebook so I can get some information we can use in the case against you or against whatever the client. And there's still a degree of deception there unless you disclose the reason for the friendship, because the default presumption is we just want to be friends, see where you're eating dinner or whatever.
You know, for someone who's old, you're pretty savvy on this Facebook stuff.
Yeah, I talk savvy. But, I could add another thing that I learned about this on the Facebook. It's the same thing under a different rule that a lawyer who's picking a jury cannot make a friend request on Facebook of prospective jurors because Rule 3.5 says that lawyers cannot have ex parte communication with judges, jurors, or prospective jurors. So if Google, as lawyers do now, and they should, Googling all the prospective jurors, you can't make a Facebook request. You can look, as Leah says, at the public information that's not protected, but you cannot make a Facebook request. It's just a different rule. It's not so much, well, deception would apply, but there's a specific rule disallowing communications between, ex parte communications between lawyers and prospective jurors.
Well, certainly in this jurisdiction, the courts do permit the lawyers to engage in social media research, but obviously with the limitation you just stated about friending and digging deeper in such a way that it amounts to communication with the prospective juror.
Exactly.
Okay.
There's also a question here
Yep.
from someone in Iowa, because we're in several states. Can a plaintiff's attorney recommend their client to delete their social media accounts prior to deciding to sign a retainer agreement?
Well, I have a view about that. I'll get out on the limb and say yes. Or what I think what most lawyers that I know do is that they counsel their clients on the use of social media as it relates to their disclosure of information that is going to be the subject of the litigation.
And I would add to that, if you got a client who's defaming somebody on their site, you might advise him to take it down. But
Yeah,
at least in my opinion, the lawyer needs to keep a copy of what was up there.
Yeah, there's even I don't know if the Wayback Machine has that or not, but I think at least in the context that I've had it come up in is when, and I think there was reference to it already today, that you represent this client who claims that he has these enormous lasting physical injuries that compromise every aspect of his activities of daily living, and then he's out there at a trampoline park doing cartwheels. I mean, that's a bit inconsistent with what you want to present in your case. I mean, okay. I mean, there you go.
Well, there's also a question from Edward that's asking, hypothetical involved a witness, not a party. From an ethical standpoint, is there a difference?
So just to be clear, the question is, could you befriend, you have your secretary, the full disclosure of her name and who she works for, but she friends a witness in the case so that she can seek information that would be used by the lawyer to impeach. Is there, I don't know. Is there,
right.
I think the analysis is the same. The issue is using deception to obtain information or to obtain evidence in the case. And so I don't think that matters whether it's party or not.
I want to be the devil's advocate on that one. Okay. So I find so there's a witness who's an eyeball witness. And he says, my client on the police report, he says that I observed the guy who became the plaintiff, run the red light. And then on his Facebook page, he's talking to his friends about how, he's hoodwinked everybody in terms of what he saw there, but, he knows things that would change the case, but he's not coming forward. I mean, why not? Why can't I have that?
You can use it.
It's going to be used for
discovery, maybe, but you can't get it through deception. So you'd have to get it through discovery some other way.
I mean, just looking at the plain language of the rule, it's in the course of representing a client, the lawyer shall not knowingly make a false statement of material fact or law to a third person. So it doesn't matter whether it's the client or a party to the case. It's
No. My secretary disclosed who she was. She befriended John Smith, who gave a false statement, or he gave a statement about what occurred, that on his Facebook page he posted that information that would clearly indicate that he lied. How is my secretary finding that out by looking at his Facebook page a deceptive act?
Well, again, it goes back to what we were saying before. Did she see this on a public Facebook account? Did she friend him? In friending him, what were the representations that were made or not made? I think Judge McKoski said it, you have to go beyond just having the firm name listed or just friending the person, but really say exactly what you're trying to do there if you're going to friend somebody to get information that is otherwise private.
Okay. All right, I think the lawyers beware of that one. Be careful. Lesson learned there. All right, Pam, are you ready? Hypo 7?
Yes, 7, right.
Okay. 4 days before an attorney was sworn in and after passing their bar exam in State A, they were arrested and charged with disorderly conduct after engaging in an altercation with a patron at a bar. Once again, 4 days after passing the bar. The attorney did not amend his character and fitness disclosures with State A to reflect this incident. 5 years later, 5 years, the attorney filed an application to be licensed in State B. As part of that application, they filed character and fitness disclosures that included the arrest in State A that occurred prior to their licensure in that state. At this time, the attorney also advised the state's attorney's, the State A Office of Attorney Admissions about the arrest that occurred 4 days before the swearing-in ceremony. Question: is the attorney subject to discipline in State A for their failure to disclose the arrest prior to the swearing-in ceremony in State A? I think that one is on Jamie first and Leah second, if I may.
So 8.1 talks about bar admission and that you have to fully disclose all matters when you file your character and fitness disclosures, when you're applying for the bar exam. You agree that you are going to amend as things change and update. So yes, he is subject to discipline in State A because he did not amend those disclosures. This is a real case. In this particular situation, they did take into account the fact that he had been practicing in good standing, had never had a complaint or any other problems with the rules of professional conduct throughout his time of practicing, and they used that as mitigating circumstances in the discipline that they administered upon him. But he was disciplined.
Leah, anything to add there?
I agree. Nothing really to add. I believe Jamie's talking about an Illinois case, relatively recent, where a lawyer was censured. The lawyer had failed to update he had applied for admission in 2020, and then while the application was still pending in 2021, he was arrested in another state, actually, in Texas, where he was also licensed for an incident with his dog. And then he failed to update that. Then when he was applying for licensure in another jurisdiction in Florida, he disclosed it on that bar application, and that's how it was discovered in Illinois.
Interesting.
We have a question that's coming in from many people, James, Kim, Dennis, and others that say.
We'll go for it. We have other polling questions here on this one, Pam, so go for it.
Well, but does it matter that it was the hypo says person was arrested and not convicted? What about the presumption of innocence?
No, the questions on your character and fitness ask for more than just a conviction. So they ask if you've ever been arrested, detained, cited, warned, anything. So it covers any sort of interaction you might have with the police. So it doesn't matter whether it was a conviction or not. You do have the responsibility to report it.
Can I ask you a question, and maybe this one's for Leah, but where is it determined that's a fair question? I mean, are these questions on those forms approved by the Supreme Court or by a committee of the court or by the disciplinary commission itself committee, or how does that happen? I mean, I tell you what flashed in my mind a moment ago is that there are loyalty things going around saying, who did you vote for in the election? Okay, or did you vote? Okay, or who do you think won the election? Stuff like that. How is this any different? I mean, it's a soft question. Guy gets elected or gets arrested. He is exonerated. It was a phony charge to begin with, and now he's getting jammed up about it.
So I
Bad
think
Bob
this would be
here.
more for the Illinois Board of Bar Examiners, the Illinois Board of Admissions to the Bar, which is another Supreme Court agency, not the ARDC.
Right.
So I would assume, yes, that those questions are vetted by the Illinois Supreme Court, and the character and fitness process is designed to, assess lawyers' fitness to practice law. And I think all of those questions bear on a potential lawyer's fitness to practice, although they may not necessarily preclude admission, but it's important for them to understand, what is in the lawyer's background and assessing the lawyer's fitness or whether additional questions need to be asked.
Good.
Yeah, they're looking at the totality of the circumstances in the lawyer's background. And that question is consistent across the United States. So it's not just an Illinois question. That question pops in every single character and fitness questionnaire across the United States.
Well, that's a good point. Are the character and fitness questions uniform throughout the country?
Not all. Many of them are similar, but it's not 100% uniformity across the country.
Great.
What if the charges were dropped or later expunged?
Still got a report.
There you
If
go.
they're sealed under an
happened to the
elephant, you
person?
got a report.
What if it happened when the person was a minor when it happened?
Yeah, you got a report.
Let's go on to our next polling question. You got to report. Assume reporting. When in doubt, report.
Bob, before we move on, I just want to point out something that is not well known amongst the bar, and that is there's something called conditional admission to the practice of law. And sometimes when a potential lawyer or an applicant to the bar has exhibited conduct within a certain period of time that raises questions, they may be conditionally admitted to the practice of law. It's confidential, but the ARDC then monitors anybody that is placed on conditional admission to the practice of law. So some of these questions that are being asked are necessarily to deny admission, but to identify potential issues that may warrant a lawyer being placed on a confidential probation for a period of time to ensure that they're supported in their early years of practice.
Makes sense. Pam, what's the next polling question? It's what if the attorney disclosed the arrest 2 months after being licensed in state A? Would that still potentially be subject to discipline? So
I think that, yes, they could potentially be subject to discipline. I think that's a closer question about whether, the ARDC would want to actually take that up because they're coming so close in time. This one was a few years later, so there was a significant amount of time between it, but yeah.
And related, could state B, in this instance Florida, using as an example, deny the attorney's character and fitness application for failing to disclose the arrest to state A, even though the attorney disclosed it timely to state B? So in other words, you disclosed it to us, but you didn't disclose it to state A, so you're in trouble. Can that happen?
They most certainly could.
Yeah. Okay.
Just a question here. Are these character and fitness applications confidential? Somebody's asking.
Yeah,
I think so.
The file processor sees them. If the applicant is referred out to a character and fitness interviewer or a panel for further investigation, those people would see it, but it's never publicly put somewhere. So it's not like posted on a site where everyone can see someone's answers.
So hypothetically, in that regard, let's say a lawyer has a really bad relationship with a client. Could the client theoretically dive into the lawyer's application with the bar and say, hey, I happen to know that things that the lawyer said to the state of Florida or Illinois 20 years ago to become a lawyer are untrue, and I'm ratting them out now? Has anything like that ever happened? Yeah.
No, No, the lawyer would have had to have said to the client, hey, I lied on all my character and fitness questions. And the client's going to go, what's character and fitness first? And so they're going to have to explain all of that. And that's not going to happen anyway. So
There you go. Okay. All right, next, Pam, next, hypo. We got a number to go here.
right,
All right, number 8.
right.
So this kind of stuff's going to come up a lot in the future, I'm sure. The lawyer prepares a memorandum in support of a motion to dismiss using generative artificial intelligence. About 90% of the memorandum is verbatim from the product produced by the AI tool. The lawyer thoroughly reviews AI's work, including case citations, before submitting the memorandum. Polling question: do the rules of professional conduct require that the lawyer disclose to the court that artificial intelligence assisted in the preparation of the memo? Yes, no, or I don't know. We're going to start with that one. We're going to talk to Judge. Judge, what do you think about this?
Well, there are a zillion questions about artificial intelligence, and especially generative artificial intelligence, that are just popping up all over. And one of those questions is, if you use it as a lawyer, do you have to disclose that fact to the court? Now, in my opinion, there's the argument that you have to disclose it under Rule 3.3, imposing a duty of candor, is pretty weak. I personally believe there's really no rule of professional conduct that requires disclosure. But the best answer is check for this read question, check the local rule for your court. And I've got 2 of them here on the next slides. On the next slide, standing orders regarding use of AI, and they vary. We have the magistrate from the Northern District of Illinois that says a party using generative AI in preparing material has to disclose on the pleading that it was used. There's another judge from Ohio who prohibits, under apparently some argument under Rule 3.3 that would be a little vague to me. He precludes attorneys from using artificial intelligence in the preparation of anything. And there are some courts that do this, although, like I said, the basis for that seems pretty weak to me. I also... Go ahead.
Leah, do you have an answer to that Illinois just came up with, as well as the ISBA, Leah?
Yeah, and so our court in Illinois has said that it is perfectly ethical for lawyers to use AI in the practice of law. I actually think it's impossible for somebody to, I think it's not reasonable to preclude it. It's impossible for us to avoid it. It's baked into a lot of things that we're using without us even knowing it. And so the issue becomes, what do you do to make sure that the outputs are accurate? And the lawyer in this fact pattern did exactly what they were supposed to do. They verified all the case citations. They read the cases. They made sure that everything was what it was supposed to be. And so they took responsibility for the work. And so that's what that's what a lawyer is supposed to do in this situation.
Yeah, and to that point, I mean, just even today, Westlaw held a CLE program on Westlaw Precision with AI-assisted research, with their product, AI-assisted research and co-counsel. I mean, and what caught my attention, Leah, when the fact pattern was when I first read it, was that the lawyer, in fact, reviewed everything that was provided. It says here, that the lawyer reviewed AI's work, including the case citations. There, as we all know, or if you've been paying attention to this issue, there have been some reported cases where lawyers have gotten in really a lot of trouble because they'll let AI write a brief for them. They'll submit the brief, and the AI's made up phony quotes, phony cases, phony citations. Are pretty remarkable. But this stuff is not going away.
And I could add, I think that Leah mentioned the Illinois Supreme Court policy they issued in January of this year on artificial intelligence is pretty telling. They say in that policy that the use of artificial intelligence, including generative artificial intelligence, may be expected and should not be discouraged. And that policy says disclosure of AI use should not be required. And so I'm sure different states do different things, but Illinois Supreme Court policy, it's aspirational, it's not an order, but it says disclosure by the lawyer is not necessary, should not be required.
Yeah, and it's interesting. Well, hold on, Pam. I mean, one of the interesting features to me is, I'm curious as to when Judge Magistrate Cole, issued this remark, because he's one of the most brilliant guys I know. I've known him as a friend and as a colleague long before he became a magistrate judge. He's one of the best judges we have over there. And it just strikes me that the disclosure of the use of AI violates work product. Or at least there's that argument there. So, this is going to be an evolving subject matter, I'm sure, for the bench and bar for quite some time to come.
There also
many.
is.
Go ahead.
Go ahead, Judge. Judge, let Judge talk.
No, that's all right. I've talked enough. There's a recent Illinois ABA opinion 512, that is referred to in the materials, that is a detailed analysis, rule by rule, of a lawyer's responsibility when using generative artificial intelligence, including should it reduce your fees that you can charge? Do you need a provision in your retainer agreement about it? Do you need informed consent from the client before you use it, which would mean discussing the risks and benefits of artificial intelligence use? There are a lot of issues here that I think lawyers need to confront, including whether the law firm or the law school or the state agency needs a policy on AI. And as an introduction to that, for lawyers and judges and law professors to become aware of the issues, it's a good opinion 512 to read that sets forth all the possible issues, or most of the possible issues, with artificial intelligence.
That's great. Thank you for that, Judge. Pam, go ahead.
Right. We just have dozens of people asking, but if you use under Lexis or Westlaw AI, does that fall under the disclosure requirement? In other words, you're using that as a research tool, and there's many people asking if there's a disclosure requirement, do you have to say that you use the AI tool in Lexis and Westlaw?
Lexis and Westlaw, the old-fashioned Lexis and Westlaw, where you get cases, has not been classified as generative artificial intelligence because it doesn't create a content product. Generative AI means you produce something. It could be a motion, it could be a photograph, it could be a video. Normal kind of Westlaw, no. If Lexis artificial intelligence or Lexis Plus or Westlaw Plus produces content, then at least the ABA would say that's generative AI. And according to the ABA, I'm not saying if I agree or not, you need to get informed consent before you can input client information in there. And there is some basis for that, because once you input client information into the AI tool, some AI tools use that in their self-learning software or whatever it is. So
and that goes to my point about the work product issue too, though. But I mean, I think there are two different things here. One is the informed consent, of course, from the client, and maybe that can be handled with regard in your representation agreement, that you could speak to that. But the other, of course, is disclosure to the court, as maybe Judge Cole is directing. And I think this is a great, Leah, this is a great topic for a standalone ARDC CLE program, a freebie, to give it to the whole bar.
We've done some, and we'll continue to put some things out. So stay tuned. But there is an AI module as part of our PMBR program that's online on the ARDC website right now.
There you go. Oh, good. That's nice. I didn't know about that. Thank you for telling us that. It's on the ARDC website?
That's correct.
There you go. Okay, 5,000 people. Now you know where to go. Okay. Pam, let's go. Unless you got a couple good questions, Pam, and then we can move on to number 9.
Well, I think people mostly have mostly answered them because, as I say, they are just concerned about that, questions like how long is this going to be before it's going to be accepted, and become, when are people going to admit that AI is smarter than humans? And some are more comments. Bruce Pfaff says, Bob is such a creative mind in the way he is viewing these things. But I think that most of the questions have been answered, other than, as I say, in terms of, like you say, it divides really the questions here into two. What do you tell the client when it comes to billing and you use generative AI versus what you're telling the court, and you have to see, like you had mentioned, Bob, what the local rules are, what each judge requires, and like
Right.
Leah had said, what the
If
state
it's a,
advisories
I
are.
mean, if your representation agreement authorizes you, of course, and speaks to the, legal research and all of that, this could be covered. But I think the moral of the story that we're getting out of this is it certainly wouldn't hurt you to expand that subject in your representation agreement and disclosure to the client then. So,
Right.
okay, we beat this one up pretty good. Let's go to number 9. An
Okay.
attorney maintains a virtual office practice. This means that all communications with clients, storage of documents, and access to information about client matters are conducted through the internet using the secure computer services of a third-party vendor, i.e. cloud computing. Is that an ethics violation? Yes or no? I think we start with Leah and Jamie.
Yeah, so, all right, so this scenario, the attorney's operating a virtual law office, utilizing cloud-based services to communicate with clients and store sensitive information. And I think there's some rules that are implicated here, or at least that we need to look at to see if this is proper. So the first is Rule 1.1 regarding competence. And as part of that, or part of the comment to the rule requiring attorneys to be competent, it requires attorneys to maintain the necessary knowledge and skill regarding relevant technology. So what do attorneys understand about the software services that they're using? Communication under 1.4, are attorneys required to communicate with their clients about how they're storing sensitive information? And then confidentiality is, what are their duties with respect to maintaining confidentiality when information is stored in the cloud. So the ISBA has an ethics opinion on this, and essentially, there's nothing inherently that's an ethical violation for a lawyer operating a virtual office. With that said, there are certain things that they say that a lawyer should put in place when doing this. And so the first one is reviewing cloud computing industry standards and familiarizing oneself with the appropriate safeguards that should be employed. What I would say here is that's probably easier said than done, or probably difficult for most attorneys who are maybe not as tech savvy to really understand the industry standards and the appropriate safeguards. So I think a better approach might be to adopt a vendor management program and use standard vendor security questions. Okay, and there's templates and guides that are available online for something like that. Another suggestion of the ISBA is that lawyers investigate whether the provider has implemented reasonable security precautions to protect the client data from inadvertent disclosures, which includes things like using firewalls and password protection and encryptions. They suggest investigating the provider's reputation and history, things like inquiring whether the provider has experienced any breaches of security, and if so, investigating those breaches. And, I want to say that's an important question to ask a vendor about whether they've experienced any breaches, but it really is not as safe as it may sound, because vendors who have never experienced a breach or say that they have never experienced a breach may simply have not just had good detection methods in place. And so they may have experienced breaches, but not be aware of it. So that's not really a great litmus test. The ISBA also suggests requiring an agreement with the vendor to reasonably ensure that the provider will abide by the lawyer's duties of confidentiality and will immediately notify the lawyer of any breaches or outside requests for client information. They suggest that requiring that all data is appropriately backed up on the lawyer's under the lawyer's control, so the lawyer has a method for retrieval of the data. And that may not be something that all lawyers can do. It's okay to what I want to say is it's okay to outsource the backup and storage function to a cloud vendor. It should not be interpreted that lawyers are required to maintain independent local backup repositories, like on premises. And then finally, the ISBA suggests that lawyers require provisions for reasonable retrieval of information if the agreement is terminated or if the provider goes out of business. So in a nutshell, there's nothing inherently wrong with this, but there's certain safety precautions that lawyers should follow to ensure that they are adhering to the requirements under Rule 1.6 to maintain client confidences.
Jamie, because then I have more to add. Go ahead.
Yeah, I agree with everything that Leah said. I think that's something else you want to consider when you have these cloud-based services is what is your policy going to be if the provider tells you there's been a breach? How are you going to handle that with clients and having an internal policy so that you and the other attorneys in your firm know how are we going to address this with clients so that we can get the information to them, but also help protect them and make them feel secure in the information that's out there about them.
Yeah, well, what jumps out to me, of course, when I first talking about this being one of the hypos is I've had one friend who has been way ahead of the curve in having a paperless office, right? But then he ramped that up with really enhanced technology of firewalls, dealt with not only dealing with the vendors, but his own providers of security services for firewalls for his system. Because one of the things that can and does happen is that these folks will try to get into your system. They will then try to download the client information, and then you're going to get a phone call that says, hey, you didn't know this. Hi, Charlie, you didn't know this, but you have a problem. Well, what's the problem? Well, I have your client's information, and I'm going to post it everywhere unless you pay me a ransom. And I hope you have ransomware insurance. Why don't you call your provider, tell them about this call, and I can work with them so that you can get your information back, and we will all have a nice day. I mean, those are real phone calls that are taking place across America to law firms. And so if you're going to enhance up your virtual office, the more you store electronically, the greater the need is for you internally to have protections and training to your staff about opening up emails that come to them that they don't know, and they click on the attachments, and all of a sudden your paralegal has unwittingly let in someone, a bad person, into your system who's then going to grab your client's information. And this is only going to get worse because nowadays so much client information, like in the injury field, our injury firm, we get medical records all the time, right? And those are HIPAA protected pieces of information that all of a sudden can be out in the public domain because somebody stole them, and now they want to attack it, and they want you to pay them a ransom. Check with your malpractice insurers. Make sure that this kind of stuff is covered under a policy, that you have services. They will bring in professionals to not only deal with the ransom request, but they will also have professionals who will go into your system and try to find out where the breach was, so that they can identify how the breach occurred and then train around that with your staff. What I'm describing is a very real problem that I know law firms have had. So,
Bob, you're absolutely right. Jonathan even mentioned there's insurance policies that pertain to the use of internet technology, but we have several questions asking, is the cloud really secure? Can you rely on a vendor's representation to that? For instance, is using a big vendor like Google, I'm combining questions, Google, Dropbox, Apple, Microsoft, without any further inquiry sufficient? But what if the cloud provider goes bankrupt or is otherwise unable to provide the client data? I mixed a bunch of questions in there because we got a lot coming in. I don't know who wants to address that.
Yeah, I don't
Leo,
know that all of that is a question for today that we can answer. I think we've identified these things as being real problems that require, as Judge would say, hire a lawyer. Okay. I mean, this is serious stuff, and you need some professional counsel about how to be protecting your clients and yourself.
Well, I agree with that
Right.
statement, Bob, but I would really stress the importance of doing a security risk assessment on any vendor. I don't care whether it's a big name or not. I think getting those assurances in writing and understanding how information is stored and how it's protected, and understanding the agreement between you if there is a breach, for instance, is really important.
Right. Absolutely.
someone asked, do you have to explain that also, that if you have a virtual office, do you have to put that in your retainer agreement with your client to tell them that that's what you're doing? That's what you have?
No, I don't believe that you need to disclose that to the client, that their information is being stored in the cloud. I'm assuming is the question.
Right.
Right.
That's what I interpret. Yeah. I mean, I think nowadays it's a given that people know that a lot of their confidential information can be dealt with and handled electronically. That's a given. I don't know of an office that doesn't have a computer. So there you
Someone
go.
just wrote the ISBA Mutual Insurance has that kind of protection, just to throw that out there.
There you go. This is all good.
Okay, so we had
Another program for the ARDC.
Okay, we got to move on. Number
All right.
10.
Number 10. Moving on. Back to Facebook. On Facebook, lawyer described the use of an ungrateful former client for whom the lawyer obtained a not guilty verdict on a DUI charge and only charged half of the lawyer's usual fee. The day of the acquittal, the client filed an ARDC complaint against the lawyer. Okay. So here's the polling question. The lawyer's discussion of the former client's case on Facebook, does that violate Rule 1.6? Does it violate in a couple different ways? Did it not violate the rule? And did it violate, I mean, there's just are there a lot of violations here of 1.6? And we'll start with the Judge Ray.
This scenario is designed to emphasize one of my favorite rules, 1.6, that Leah just showed a slide on, that has a very broad requirement. A lawyer cannot reveal information relating to the representation without the client's consent. Couple exceptions. That rule it emphasizes that rule when it comes in contact or clashes with social media and the internet, because it's so easy to violate this rule. And it's not just like you having lunch with a friend and telling them all about your cases, which you're not supposed to do without informed consent. That stays with your friend. This is the universe when you put something on the internet. So generally speaking, whether it's a Facebook post like this lawyer did, or a blog post, or a response to online criticism from one of your favorite former clients, or the lawyer belongs to a listserv and is asking questions incorporating information from his case, technically, and I'm not saying the ARDC is going to charge you, but you cannot reveal information in responding to a client criticism online, or in a listserv, or in a TV interview or whatever. Reveal information without informed consent. And the rule doesn't say, it isn't limited to client confidences or secrets. It's any information, revealing information related to the representation, whether you read it in the newspaper, it's public, or whatever. And that's the point of this hypothetical, to be careful with things like this. Now, the rule does have an exception, a couple exceptions, and one is if you defend yourself in a malpractice suit or defend yourself from an ARDC complaint, you can bring up client information related to the representation, obviously. But in my opinion, even if you got an ARDC complaint and can present information regarding the representation at the ARDC investigation or hearing, you're still not supposed to do it on Facebook or in response to an online criticism.
Well, what if the client, wait a minute though, and then Jimmy, and I'll get to you. What if the client files this ARDC beef, then goes on Facebook and says, today I filed an ARDC beef with because of lawyer Smith's bad handling of my case, and he says all this stuff about the lawyer and so forth that mirrors the complaint at the ARDC. Does the client waive the privilege then, and can the lawyer then, is it just open warfare? The lawyer could say what he wants and back and forth?
Well, I'm not sure, Lee would be the expert, I'm not sure a client can waive a rule of professional conduct. But in your situation, files an ARDC complaint, then goes on the internet to blast it all over, the lawyer could argue that this response comes within the exception to defend yourself. If the lawyer did that and the court or the ARDC bought that, and maybe they would, the lawyer would have to limit the use of that information to directly respond to what the client said, in my opinion.
Okay, Leah?
Okay, so I agree with everything that was said previously. The breadth of this rule is something that everybody must appreciate. The rule protects all information relating to the representation. It does not matter if it is publicly known. It does not matter. If you learned it during the course of the representation, you're not allowed to share it, period. The two exceptions, establishing a defense in a criminal case or in a civil claim like malpractice or a lawyer disciplinary matter, that is it. It needs to be limited to that. If somebody posts an online negative review, a Facebook rant, even if it is related to the lawyer disciplinary matter, the lawyer is still not allowed to go and respond to that. They are able to defend themselves before the ARDC. Once they take it outside of the ARDC and respond on Facebook, that's not defending themselves before the ARDC or against a civil claim anymore. That's defending their reputation, and that's different. I strongly caution lawyers against doing that. Not only would that lead to potentially a prosecution for Rule 1.6, it oftentimes serves to make the matter worse. There's something called the Streisand rule. I don't know how many people are familiar with this, but Barbara Streisand's home was photographed years ago because people were taking pictures of the coast being eroded, and her home happened to be in this photo, and she filed a lawsuit regarding it. And prior to the lawsuit, only about 4,000 people had seen this photo. After she filed the lawsuit, it was tens of thousands of people that saw this photo. So, responding to these online negative reviews or comments actually often serves to heighten the attention to it. And you're not really defending your reputation anymore. You're actually drawing attention to it. I do want to highlight an Illinois disciplinary case where a lawyer did pretty much what's in this scenario. Actually, it was a case that I handled years ago. There's a public defender an assistant public defender who, it was a very sad situation. She had actually been assaulted by one of her clients in court and was then forced to continue to represent this client. As a cathartic exercise, she began blogging. And she blogged about her bird watching hobbies, but then also started blogging about her interactions with clients. Sometimes she referred to the clients by a first name, sometimes by their jail ID number, sometimes by a derivative of their first name. But in any event, she disclosed a lot of information about things that she learned in the course of representing the client. And she was, the various clients, and she was disciplined for violating Rule 1.6. So this is something that is a very clear-cut rule. If you learned the information in the course of the representation, unless you're defending yourself in a criminal case or in a civil claim, you cannot disclose the information.
Thank you. And by the way, just because then I think we've got to move on, but formal ethics opinion number 511, slide 60, Pam, does this add further clarity to Judge? Does this add clarity for Judge or Leah? Does this help us?
It does. It specifically discusses revealing client information in a listserv, a lawyer's listserv.
Okay, great. Okay, we're moving right along here. Pam, do you have a question or two that we could still take? We got time to take. We got three hypos left.
A quick one. Right, because we got to move on here, but can you limit a client's ability to bring a bar complaint in the representation agreement?
No,
No,
We're not.
no,
That was a question.
no. That's an easy one.
Okay,
All right, even I got that one
right,
right. All right,
okay.
okay, fair enough.
So,
Maybe you got a
number
wish.
11,
All right. Okay, so
I figured.
lawyer Devin Downs here. We got to have a conversation about these names. All right, lawyer Devin Downs represents client Larry Lotto in some construction matters relating to his business. Downs' representation of Lotto in those matters is concluded for about a month. Then Lotto wins the lottery. He calls Downs and asks for help collecting and investing the money. Downs' personal financial situation is a mess. Business is slow and he can't pay his bills. So Downs asks Lotto for a loan. Lotto, trusting his lawyer, says sure. Okay. So query, is that an ethical violation at all? What do you think, Leah?
Yeah, so Rule 1.8A prohibits lawyers from entering into business transactions with clients unless certain conditions are met. So the three conditions are, it be in writing and the terms be fair and reasonable to the client. Two, the clients have to be told that they can seek the advice of independent counsel and actually given the opportunity to do so. And that advice has to be given in writing. And then the client has to be, has to give informed consent to, this business transaction in writing as well. So, in this case, I would say that Downs' request for a loan from the client violates the rule because there's no indication that the transaction was fair and reasonable, especially, given the fact that the lawyer is having some financial issues and is unlikely to be able to pay the loan. Downs didn't advise his client to, in writing, to seek the advice of independent counsel before making the loan, and did not provide written informed consent, acknowledging the risks in terms of the transaction.
Yeah, but wait a minute, Jamie, wait a minute. The hypo says that the representation was over a month ago. Is Lotto still a client of Downs?
Well, looking at the fact pattern, it seems like it, right? He's coming to him for advice on, how do I go about collecting this, investing this, and certain legal concerns that you may have with handling the money. So it
Right,
does seem like he is continuing that relationship. This
correct.
is just a
Right.
bad idea. Don't ask your clients for loans. It's a bad idea.
Yeah, and we know this is from a real case, right? I mean, lawyers do this. Certainly,
They
I've seen it
do.
in practice. Yep.
They get
Judge,
disciplined, right, Leah?
Judge, you have
Yes.
anything to add to this one? You want to add anything to this one, Judge?
there is one Illinois State Bar opinion that I thought was kind of interesting because it reinforces the rule that you can't advance money to pay for a client's hospital or living expenses. But it did say, the opinion, that it is okay that an attorney can help a client get a loan to pay the attorney's fees. So there is that little exception in there I thought was kind of nice.
Yeah.
We have
Okay.
a question.
Well,
What if it was for an interest-free loan for personal purposes and hence not a business transaction?
Depends on
I,
your definition of business
yeah,
transaction.
I don't think it makes a difference at all. I mean, it just, I mean, look, the lawyer's in a position of authority with the client. The client is always vulnerable. The client's there seeking legal counsel because they don't have the expertise or experience to handle the matter on their own. So they're by definition a bit vulnerable. So there's a disparity in bargaining. It's not an arm's length transaction. I don't think. I think that's how the board would look at it.
You're absolutely
Okay.
correct.
Yeah.
Yeah.
Okay. All right. Pam, let's move on to number. Well, we have time for one question, or maybe two, maybe.
Okay, well, Mike here is asking, and I'm trying to figure it out for clarification. Is independent counsel advice required for a counsel to enter, I'm trying to figure out what he's trying to say here. Required for a client to enter into a contingency fee agreement with the lawyer. So in this case, so in other words, I guess what he's saying is you have independent counsel who's asking you this, then can you?
I think we've touched on it. I think at least I interpret that question being, given the nature of this relationship, if the lawyer is going to try, if it's legal for the lawyer to try to borrow money from the client, at a minimum, should the lawyer be recommending to the client that the client get independent legal counsel? Is that the question?
Yeah, I think it may be, yeah, it's written that, yeah, I think that's what he means. Mhm.
Okay. And I think we all agree that he shouldn't be asking in the first place.
Correct.
So,
Yes, I
there you
think that
go.
was the conclusion. Right,
All right,
and
let's
some
go.
Howard is saying here, in my experience, it usually happens in reverse, where a PI attorney lends money to the clients, and this obviously is ethical.
Those guys
What about
shouldn't
an
be lending
attorney
money
receiving
to the client.
stock?
That's a
What
no-no.
about an attorney? Right, what about an attorney receiving stock in a client's business in place of cash?
In place of a fee? Oh, that might be, if it's in place of a fee, that might be
In place of
permissible.
a fee. Mhm.
Well, the issue is going to be then, is the fee reasonable, and how to
Right.
determine the value of that stock. So, the
Yeah.
rules, Rule 1.5 requires that fees are reasonable. So that would be the concern there.
Is there a difference if the client is a close family member?
Worse.
Yes.
Let's go to number 12.
Well,
All right. Number 12. The judge is an administrative law judge in State C. Last year, judge served as a volunteer judge for a local middle school mock trial competition, which was held in a courthouse. During the competition, a judge presided uh, from the bench and wore the judicial robe she wore while presiding as an administrative law judge. Judge is currently running for re-election and would like to post pictures showing themselves interacting with the students from the bench while wearing the judicial robe to be in their social media and web campaign. The pictures would include a message about judging the mock trial competition and congratulating the students on their performance. If the judge posts those pictures, is the judge subject to discipline? Actually, I think here we start with Jamie.
Yeah, so I mean, what we're really looking at is, are you being truthful in what you are showing in that picture? So there is an element you need to be showing that you're not being dishonest in how you're providing that information. This does come from a real opinion, and it basically what the opinion came down to was, if you wear the robe normally, yes, you can wear the robe, but you need to, if it's not a picture of you actually working on the bench, you need to explain what's happening there. And I think in that fact pattern that they do explain that they're judging the mock trial competition and that it's not a real case in wearing that robe. But if you don't normally wear a robe, in that particular situation, you shouldn't be posting those pictures of you wearing a robe to show, oh, this is how I do my job, because that's not actually showing accurate information.
So Judge, when I'm defending that judge before you in some complaint, and what are you going to do when I talk about free speech in the First Amendment? So, Your Honor, what do you think about this one?
Well, the opinion says exactly what Jamie says. It says, and this is an illustration, as you're pointing out, Bob, of the conflict between the ABA's position and a lot of people's position that judges shouldn't be involved in politics or political campaigns, that ethically that hurts public confidence in the judiciary, clashes against the fact that at least some judges in 40 states are elected or retained. So the ethics rules have made some concessions to allow judges to campaign, even though politics is supposed to be contrary to public confidence. If I'm defending the judge, I certainly make a First Amendment argument, especially since this is political speech, the most important kind of speech, I would say, under the First Amendment. And I would also say The caption that we put in the photo saying he was an administrative judge isn't going to confuse anybody. They know he's not a circuit judge, and there is absolutely nobody who's been deceived or evidence of that.
All right, we have to move on to our last hypothetical, number 13. Okay, Harper Hassel is a real estate lawyer who is representing her girlfriend, Harley, in the sale of the marital residence. Harley is getting a divorce from her partner, who Harper hates because the perpetual lying and cheating, hereafter cheater. Harper gets the keys to the marital residence for the final closing inspection. Excuse me. Harper gets to the house an hour before the inspection is scheduled to start and goes into Cheater's home office. Cheater's computer is on and Cheater's Facebook page is open. Harper goes to the computer and finds information about some of Cheater's current sidekicks. Using a made-up name and pretending that Harper and the sidekick have the miserable cheater in common, Harper's friends, the sidekicks. Harper also finds some financial information on the computer's desktop. Harper points it out and later prints it out, and later, when she is alone with Harley, hands Harley the printed financial information. Over the next several days, Harper corresponds with Cheater's Facebook sidekicks, finds out juicy tidbits about Cheater's outside activities, and hands over all the information to Harley. Harley takes all of this new information and gives it to the divorce lawyer, Vinny the Viper. Vinny Viper never asks Harley how this information was obtained. Viper just used it in the divorce case to accuse Cheater of perjury, among other things. Wow, that's a mouthful. So here we go. Pamela, what is the after question? Okay, we're doing that. So are there, Leah and Jamie, are there concerns here about Harper's conduct, about Viper's conduct? What rules would you guys be looking at? Can you please take over?
Sure, I'll be really quick and hand it over to Jamie. I would say Harper's conduct violates multiple ethics rules. 4.4, respective rights of third persons. Rule 8.4C, which is dishonesty, fraud, deceit, or misrepresentation, are a couple of the rules. I would say Harper should have advised Harley to obtain the financial records through lawful discovery instead of obtaining them the way that Harper obtained them, and then also that Viper should have inquired about the source of the information and should not have used it if obtained improperly. So that's my really quick answer given the time limitations.
Yeah,
Well,
I agree with everything, and I would say that Harper needs to start watching Bravo if she wants the juicy stuff instead of digging
somebody says-
into.
Right,
Pam,
this
you
is a
have
great
one
TV
question, Pam. There's a great TV series.
Okay,
There
would
you
your
go.
view, yeah, somebody said, right, but somebody is asking, would your view change if the marital residence belonged to Harley before the marriage?
I don't see why. I
No,
would just be focused on the conduct, right?
Correct. I don't see any difference. I mean, going into the house and again, looking at the Facebook without permission to do so, taking financial records and so on and so forth, in that way is still improper, regardless of whether it was owned by Harley initially or not. It's the
You know, this sounds like a burglary to me, separate from the rules. At least
Well, yeah, I
at
was gonna say
that.
there might be some. Yeah.
And the rights of the respect for the rights of third parties is what's that all about, Jamie?
So you don't want to do anything to purposely embarrass someone else or violate their rights when they're going on. They're pretending to be somebody else and trying to extract this information and stuff like that. They are using it to ultimately hurt Cheater, but also these communications could embarrass the people that they are talking with about that because they don't
But-
know who the person really is.
David, though, from Indiana is asking, though, what if the computer belonged to Harley?
You're still going into the website. So regardless of whether the computer belongs to Harley, you're accessing the the specific Facebook page that belongs to Cheater, not
Yeah.
Harley, which you could do
Yeah.
from any computer, and
Yeah.
it's still wrong.
Exactly. And then
Well-
again, she created a fake identity to correspond with the other sidekicks and so on and so forth. So we're back at Rule 4.1, truthfulness in statements to others.
There you
And
go.
Larry's asking, what about using this knowledge of the financials just to create specific legal discovery? Would that be a problem?
That could be, of course. I mean, for the very many reasons we talked about today. You're using it to gain an advantage that in violation of people's rights that you would not maybe otherwise have, I think. Well, listen, I'm pretty sure, Pam, you're about to announce that we're at an end. I know that the computer is turning some people off already, and Judge McKoski and Jamie and Leah, you are awesome, and I am grateful. And I know that many thousands of people here today appreciate your expertise, and we really want to thank you for making time today to participate in this program.
Thank you, Bob. Thank you.
Everyone
you
is
so
saying it was a great program here. And in conclusion, we do appreciate, as Bob said, your presence here today, as well as all the thousands of attendees. And that concludes today's presentation of Ethics Jeopardy Answers and Questions. A link to the CLE certificate process will now appear on your screen. Please take the time to request your certificates as soon as possible. This link will also be emailed to you tomorrow morning. On behalf of all of us here at Clifford Law Offices, thank you for joining us and have a safe evening.
Bye,
Good night.
everyone. Thank you.
Thank you for using the conferencing center.
Okay. I think we're supposed to disconnect now. See you, panel.
And we are clear.
Bye.
Thank you.
Bye.
Thank you.
Well done,
Bye.
all.
Yeah, thank
Oh,
you.
and my
Lots of
headset
fun.
just turned off.
Okay. All right. Bye, guys. See ya.
Bye.
Bye.
If
Thank
you
you.
guys can hear each other, it's fine. You can talk.
Okay.
Can you hear me, Pam? Nope, you're gone. Event.